Hello, my name is Casey Copeland and I'm the Pro Bono Director here at Legal Aid of Arkansas. This is just a quick refresher on estate planning issues for volunteers and attorneys who may be coming to help at legal clinics. If you have any questions, want to see our forms or templates, or would just like some follow-up training, please send me an email at ccopeland@arlegalaid.org. Okay, let's get started. Our first concern is capacity. Does the person sitting across from us, the client, do they have the legal and testamentary capacity to make their estate plan? Legal capacity is pretty easy. Basically, are they an adult, not under a guardianship or conservatorship? Testamentary capacity can be more tricky. Do they have a fair comprehension of the nature and extent of their property and to whom they're giving it? That's the question. Can they talk to you, answer your questions, remember and articulate their plans on their own without prompting or assistance from anyone else? If they can, they probably have adequate capacity to proceed. If not, you may want to ask another attorney to sit in and do some further assessment with you. Also, if the client's been diagnosed with any mental or cognitive condition or disability, that should stop the process. We can then talk to the client about getting some medical documentation that says they have the capacity to make their estate plan before we proceed. In short, if there are any concerns about the client's capacity, we should pause the process and consider how to continue. Sometimes the client is accompanied to the clinic by a friend or family member. This is fine as long as the client consents to the person being present during the consultation. However, we should watch for situations in which the other person is assisting the client in answering questions, correcting the client, or even giving answers for the client. In these situations, we need to think about the client's capacity and whether the client is acting of their own free will. Here, we should ask the other person to step away and then have a one-on-one discussion with the client to assess their capacity and make sure they aren't acting under any duress, pressure, or undue influence. This will protect the client's estate plan, and even the beneficiary from allegations of procurement or undue influence down the road. If the other person will not step away, if the client doesn't want them to step away, or if you have questions about the client's capacity or free will during your conversation with them, you should pause and think about how to proceed with them. Of course, it's not uncommon for spouses to attend an estate planning clinic together, and this is perfectly fine and normal because they usually want to prepare reciprocal estate plans. However, if one wants to do something different from the other, such as leaving property to children from a previous marriage, that may create possible conflict of interest. In that case, we should advise both spouses to seek the assistance of separate attorneys. It's not common for this to happen, but we should be ready for it if it does. When the client has children, we need to be sure to list all of them by name in the will or other document. This includes all living and predeceased children, natural and adopted. It's also a good idea to name them all by their full names, maybe include their date of birth, date of death if applicable. Sometimes we also include where each child lives, maybe by city or state. The exact address isn't necessary. Once listed, we can talk to the client about whether or not they want to exclude or disinherit any of them. If so, we want to make sure we use express, unambiguous language that clearly states who is being excluded by name. Again, the client can exclude all, some, or just one of their children. We want to make sure the document clearly says who falls on that list. Clients cannot exclude their spouses from their estates. Spouses are protected by the law and will have their statutory entitlements that they can take against the will. It's not common for a client to want to do this, but if they do, we should talk to them about the law that protects spouses. We should also talk to them about how property held as tenants by the entireties passes to the surviving spouse, that both spouses need to sign off on any transfer of such property to other grantees. Also, if applicable, remind clients that stepchildren are not heirs or beneficiaries of the estate unless they're specifically named and provided for in their will. Wills are still the most common estate planning tool, especially for clients at our clinics, and they're just a set of instructions on what happens to the client's property when they pass away. We need to make sure to name current spouses and all living and predeceased children. Of course, like we said, the client can exclude one or more of their children by express language, but they still cannot exclude their spouse below those statutory protections. The will needs to name a personal representative, which should be someone the client trusts to fulfill their instructions. This can be a spouse, child, relative, friend, just anyone else, as long as it's someone the client believes will follow directions and not try to enrich themselves at the expense of other beneficiaries. Parents of minor children can also nominate a guardian in their will, or they can do that by separate document that we'll talk about in just a few minutes. When it comes to how the estate is distributed, the client can be as detailed or as broad as they want, as long as the language clearly and unambiguously describes the property to be distributed and to whom. They can make specific gifts of specific items to specific people, or they can gift various percentages or lump sums to people or groups of people. What matters is that the language is clear enough that a court or anyone else who is looking at the will can tell without question what property goes where. If real property is at issue, we should talk to them about a beneficiary deed, which we'll discuss soon. If financial property is at issue, we should talk to them about naming beneficiaries and payable on death designations. The goal should be to pass as much property outside of probate as possible and to make sure the probate process of the remaining property is clear and unambiguous. Executing the will is a fairly straightforward process. Generally, we have the testator initial the bottom right corner of each page to show that they have seen and touched them all and that there are no substituted or replaced pages which have not been approved by the client. Then they need to declare or affirm that the document is their will, that they are signing it, and that they are asking the two witnesses to sign. The witnesses should be disinterested, which means that they're not named beneficiaries and are not closely related to anyone who will benefit from the will. The testator then signs at the end, the witnesses sign, and the witnesses sign the proof of will affidavit that is attached to the will. We usually have plenty of volunteers, staff, and law students at clinics to take care of the witnessing requirement. We usually try to avoid doing trusts for clients at our clinics, but they do come up from time to time. And generally speaking, our clients usually do not have the property or wealth necessary to justify making a trust, and those who might are advised to seek the assistance of a private attorney who specializes in trusts. Otherwise, the basic concern about client's capacity and using unambiguous language applies to trusts. If the client wants to use a trust as a will substitute to avoid probate, we need to make sure the document names their spouse, all their children, and uses clear language to dispose of property. We should also remember that one person cannot be the settlor, trustee, and beneficiary alone, which means another person needs to be named as the trustee or beneficiary along with or in place of the client. Further, we should also consider talking with them about alternative planning, such as beneficiary deeds, naming beneficiaries on accounts, and inter vivos gifts. We should also remember that even with a trust, we need to prepare a pour-over will to make sure we cover all their property. In the end, if we really need a trust, then they probably really need the experience of a trust attorney to help them. The beneficiary deed is usually the best way for our clients to handle real property in their estate plan. It's a deed that is executed now and recorded now, but is not effective until the grantor or grantors die. As long as the grantor or a surviving grantor is alive, they have full use and enjoyment of the property. They can sell it, lease it, mortgage it, and otherwise use it in any way. There are no restrictions on their possessory interests. The grantor or surviving grantor can also revoke or amend a beneficiary deed as long as they're alive. The deed simply acts to pass legal title upon the death of the grantor or both grantor spouses. Of course, if the property is owned by spouses, they both need to sign the beneficiary deed. Further, they can convey the property to anyone, children, family, friends, charity, or an organization. They can even convey the property to fewer than all of their children if they wish. Of course, if the property is going to a group of grantees, we need to consider how title will pass. It might go to the group as tenants in common, so that if one of the beneficiaries dies, their interest passes to their own heirs or estate, or it might go to the group as joint tenants with rights to survivorship, so that if one of the beneficiaries dies, their interest passes to the surviving beneficiaries. This is a decision the client needs to make after we talk to them about it. Further, if the property is going to a married person, we need to know if it is going to them and their spouse or if it's going to them individually. Then we should make sure the deed language clearly states how the interest is being conveyed to the grantee. In addition to wills and beneficiary deeds, we tend to prepare a lot of powers of attorney for clients, including the statutory power of attorney. This is really just a fill-in-the-blank form that basically walks you through each section. Clients can name a primary agent and a secondary agent. They can provide specific or broad powers over a range of issues. They can provide specific authority or specific limitations. They can make the power springing or durable or immediately effective. If you haven't ever reviewed the statutory POA form, it would probably be a good idea to do that and to familiarize yourself with its sections and its provisions. We also do a lot of healthcare POAs for clients. This is just a designation of an agent to make medical decisions for the client if the client is incapacitated. The power exists only during the incapacity and ends when the client's capacity is restored or the client dies. As with the statutory power of attorney, we suggest they name a primary and secondary agent. We also try to remind them that this and all powers of attorney can be revoked by written notice to the agent or upon the death of the principal. Along with the statutory power of attorney and the healthcare power of attorney, the living will is a common document we help clients prepare. This is just a declaration of the client with regard to life-sustaining care in the event they are dependent on that life support to remain alive. It is the client who is making this decision, not their agent. The agent is simply the person who will deliver the client's declarations to the medical professionals to carry out. Like the healthcare power of attorney, this is only effective if the client is incapacitated and cannot communicate their instructions to medical staffs themselves. Parents sometimes want to execute a power of attorney over a minor child, such as when the parent is leaving the child with someone or when the child is traveling with someone else. Depending on the circumstances, it's usually a good idea to put an expiration date or time limit on this type of POA. And we should remind the client that they can revoke the power of attorney at any time by written notice to the agent. Instead of nominating a guardian in a will, a parent can do that in a separate document. This allows them to provide that document to the preferred guardian without having to give them a copy of their will. However, the client should be advised that this designation does not defeat the preference for a natural parent, including a non-custodial parent. Likewise, an adult can designate another adult, usually their spouse, to serve as their guardian in the event they need one. Or a parent could nominate an adult child or someone else to be their guardian if necessary. One thing to remember is that unmarried people cannot serve as co-guardians, but they can serve separately as guardian of the person and guardian of the estate. This is usually not an issue, but can come up from time to time. Finally, when talking with clients, it's best to keep these probate avoidance issues in mind, such as naming someone as a payable on death on their bank accounts, naming beneficiaries on life insurance, investment, and retirement accounts, filling out beneficiary title transfer form on any vehicles they own, executing and recording the beneficiary deed to real property, making inter vivos gifts if possible. There are a number of tools we can use to avoid the probate process, and we should be sure to consider them and talk to clients about them as we work with them on their estate plan. Again, this was meant to be a brief, basic refresher on estate planning issues for attorneys and volunteers who are planning to attend an estate planning clinic with us. If you want more information, want to see our forms and templates, want some additional training, or just have some questions, please don't hesitate to email me at ccopeland@arlegalaid.org. Thank you for your time. Thank you for your commitment to helping our clients with their estate planning needs, and thank you.